All right, having exhausted the subject, Mr. Chairman, good luck. You may close. Sum it all up.
No, let me tell you why I'm looking for everyone to vote yes on this bill. A yes vote is a vote for reform. We started reform last year. The legislature put in place the Public Records Act requirements and the Bagley-Keene requirements. What we've learned from the Public Records Act request is we've been getting information now out of what's happening at the bar that has fed into a lot of the dysfunction and the things that we actually need to reform. We absolutely need to do reform, and that's what we have to move forward with. We need to continue that reform that we started last year. Right now, I am agnostic on unification, deunification. It's become a very volatile issue. And I get your perspective. This is a rare moment where all 10 of the committee members are weighing in on the state bar. That shows how significant that is. And I want you to stay engaged. If we move this bill, which I want to move this bill, and I think you should all be a part of moving this bill, we will continue this reform effort. There have to be significant changes made to how the bar is governed. And whether that's unification, deunification, we will sort of get there. But we need the information to know how we're moving forward. That information is going to come out of the audit, which is coming out in just a couple weeks. We're a little bit before that. That's going to drive potentially substantial changes to this bill. The governance task force was ordered by this legislature a number of years ago. They were supposed to report to the legislature in 2014. The then executive director decided it was not important, and that task force never came up with its report. We're now 2 years past that due date. It's supposed to come out in July, we're told. I hope we get it, because it will be informative to what we need to do. But if we don't get it, we still have to move forward with all of the pieces that we do in fact have. This question is up to us and Senate Judiciary and the Chief Justice. We're going to be the decision makers in reforming the state bar and addressing all of these issues. And yeah, there were concerns about the 300 complaints that were dropped in a drawer. That is not excusable. The way that the future fees were encumbered, actually because of this is all in the analysis of the 1957 statute, said that if that was the case, then the state legislature could not reduce the bar fees. That is entirely unacceptable. This bill takes action and removes that provision so that this legislature and future legislatures will not be hampered. Not only was it bad practice, but it's a way of trying to take away from the legislature its due authority to oversee and to provide regulations. In the middle of all this, there are trustees, at least one trustee, who was out in the public saying the legislature has and should have no role in oversight of the bar. So there's a tremendous credibility problem that the bar has, which is why the decision around bar governance is us, Senate Judiciary, and the Chief Justice. And I've been meeting with the Senate. I've met with the Chief Justice. We're going to be continuing to put together a plan to offer to you to be able to move this forward. Senate Judiciary and this committee will hold hearings on exactly this question of governance, and we can thoroughly vet out. We just had a real taste of the debate around unification, but around bar governance and about reforming what the bar means to the people of California, not just the lawyers, but to all the people of California. We will hold informational hearings about that to thoroughly vet it so that you have in front of you all the information that you need. Now, Mr. Ting left, unfortunately. We are not going to have a complete picture in this bill, I will tell you, by the time it gets to the floor. It's going to go through appropriations. We will do amendments as much as we possibly can. But I have committed to the chair of the Senate Judiciary Committee, and I've committed to the Chief Justice that we will not be making amendments without involving them in that process so they know exactly what we're looking to do. We will then be doing amendments probably on the floor as it moves over to the Senate. And again, you will be involved in that. It's not going to be that it goes over to the Senate and you're blind, because it will be coming back for concurrence. And if we don't get substantial, if we have not addressed all of those issues, I mean, we have the one organization that should not be in violation of antitrust, potentially very much so, because it is regulated, is managed by market participants. We would not stand for that in any other context. So if we have not addressed those, then we're not going to fix all of that this year. But I want to give you a plan enough that you have confidence in to be able to move this forward. If we cannot do that, By the time this comes back around next summer for concurrence, I will ask you to vote no on that bill. Because if we need to create crisis, we will. But I want to make sure that we have thoughtfully, deliberatively, and in a coordinated way managed the next steps of reform. First steps we should all be very proud of. We put the Public Records Act and we put Bagley-Keene in play. We have been learning from that. The public's been learning from that. A lot of the press is now starting to get information that we had asked for, I had asked for, and we didn't get as complete a picture on it. Just the fact of the encumbrance of this building, this $10 million loan on bar fees, we were told nobody knew. That decision was made without that information. As we look at the record that was created, there was information. There were internal memos that said, yeah, I think they knew what they were doing. So it was putting something in place without advising the legislature in a way to tie our hands. And if that was done completely unknowingly, without the information that was present and giving it to the Board of Trustees, there's a structural problem within the bar. And if it was, then that was patently dishonest with respect to the relationship with the legislature. And that is why I'm telling you the decision around bar governance and reform that we are embarked on is this committee, Senate Judiciary, and the Chief Justice. So that's why I'm asking you, the yes vote on this bill is moving forward our ability to drive that reform. And that's why I'm going to ask all of you. And Mr. Gallagher, I understand your frustration, but I'm going to ask you to be with us, with this committee, because if we can't be together with this very, very clear message that's been articulated today on what we expect as the Assembly Judiciary Committee, our role, our obligation of oversight of the governance of a very, very important body to the public of the state of California. And again, we're not going to tie our own hands about what those decisions are going to be. I have a great sense now of where everyone is. I'm not surprised, but I appreciate that everyone has been willing to articulate those, because that gives us that much more ability to really push for reforms that I think are absolutely necessary. That's what I'm asking you to move today. It is incomplete. We don't have a lot of answers to those questions, but we're going to start to get the data, the facts, the information we're going to need to be able to do reform. That's what I'm asking of you today. Join with me, join with Senate Judiciary. Let's work this. Let's do something we can all be very proud of, and do it on our terms, on our time, and in a way that we can have the best effect for all of our constituents across California. Thank you.
Mr. Chairman, I will entertain a motion. Moved by Assemblymember Chu. Is there a second? Second by Assemblymember Alejo. Call the roll.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo? Alejo, aye. Chow? Chow, aye. Chu?
Aye for reform.
Chu, aye for reform. Gallagher?
With the chairman's commitment that we're going to insist on these reforms, I will vote yes today.
Gallagher for commitment. Garcia? Holden? Garcia, aye. Holden? Mainshine? Mainshine, aye. Ting?
The bill is out. Thank you, sir.
Thank you, Mr. Vice Chair. Okay. Ms. Grove was next on our list.
Mr. Gatto said he's going to be less than 5 minutes.
Okay. With your agreement. With your agreement. All right. That moves us then to item number 5, AB 2748. Mr. Gatto.
Thank you. First of all, I want to thank the committee for their amendments, which I will be accepting. 2748 aims to provide victims of environmental disasters better access to remedies. It does 3 things. Number 1, it adds a year to the existing statute of limitations because folks are often unaware of the consequences of exposure. Number 2, 2748 will authorize the court to award reasonable attorney's fees once they have proven liability. That's a key thing, once they've proven liability. And third, it will ensure that any payment or reimbursement made in connection with an environmental disaster will not be conditioned upon the release of any future claims unrelated to the environmental disaster. I ask for your aye vote.
Thank you. Do you have witnesses in support?
They might have given up the ghost after that last one, but they were here somewhere.
Anyone wishing to testify in support?
Jacqueline Stern on behalf of the Consumer Attorneys of California. We think that this will enact some very common sense reforms for consumers who are victims of not only the Porter Ranch disaster, but Exide and other environmental disasters that hopefully we don't see more of this year. But we think that these are very good measures, and we support the bill as amended.
Thank you. Anyone else in support? Is there opposition? Seeing none, I'll bring it back to the committee. Questions? Opposition?
Thank you. Sorry, I was sprinting from the back.
Please.
Thank you, Mr. Chairman and members. Hal Dassinger from the Civil Justice Association of California, opposed to the bill. We have some issues with the language on the limitation on settlements. We're often in here objecting to extensions of statute of limitations. Our arguments are similar with this bill. Within 2 years of the date of the injury or 2 years after the plaintiff becomes aware of the injury, the section was amended in recent years to specify that media reports alone don't cause somebody to be on notice for the injury. We think the current section contemplates the potential for delayed discovery, protects claimants from imputed knowledge of their injuries. We think that the current law adequately provides for that. Adding a year to the statute of limitations does not increase protections for injured persons, but lengthens the time between an injury and prompt resolution of the claim. Current statute of limitation promotes justice by requiring the timely filing of actions. We also object to attorney's fees only for a prevailing plaintiff. Even in a case where the defendant has been adjudged liable for an environmental incident, there may be claims which are unsupported or meritless. The defendant should be able to collect reasonable attorney's fees if the defendant is a prevailing party. We ask for a no vote.
Thank you. Anyone else opposed? All right. Seeing none, I'll bring it back to the committee. Questions, comments? Mr. Wagner.
What's wrong with fundamental fairness? Loser pays. Prevailing attorney's fees to the defendant as well as a plaintiff.
You know that there are certain inequities within the justice system, and that would exacerbate the inequities between deep pockets versus humble citizens.
I don't understand what inequities you're necessarily talking about. A frivolous claim should not be rewarded, should be discouraged, and whether that's a frivolous claim or a frivolous defense, tell me why it's fundamentally unfair. I just am not buying it. Loser should pay.
Look, I don't disagree with you that frivolous claims have no place in our legal system, but we've known each other for a long time. We have a fundamental disagreement as to the inherent realities in the justice system. Thank you.
All right. Seeing no other questions or comments, Mr. Gada, you may close.
We think this is a just bill. It will do a lot of good. I am working with the opposition on the release of claims issue, and we expect those discussions to be fruitful, and I ask for your vote.
Thank you. The recommended motion is due pass as amended. Do you have the motion? All right. We do have a motion. I will second that motion. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Wagner, no. Alejo? Aye. Alejo, aye. Chow, Chu, Gallagher, Garcia, Holden, Mainshine, Ting.
Thank you. That bill is on call once we get our members back. All right. That moves us to item number 10, AJR 30. Ms. Grove.